This podcast was originally recorded last year. Some of the facts and events we discuss may now be slightly out of date, and so please bear this in mind when listening. We hope you enjoy the episode. Hello and welcome back to Collier Bristow's US-UK podcast. This is the second half of a two-part episode looking at US trust planning, where we have UK individuals. I am still joined by Jake Kaplan, a partner in the Atlanta office of US law firm Alston and Bird. Jake, thank you so much for joining me again today. How are you?
I am well, Aidan. Thank you very much again for having me. It's a pleasure.
It feels like only 5 minutes ago we were recording the first half. How funny is that?
I know.
So in the first half of this discussion, we were looking at US trusts as a form of US planning, estate planning, why Americans put them in place. You were very kind in explaining the sorts of trusts that are most common. I now want to throw some grit in your gears. And Jake, that's grit, not grits. I've never understood grits. We're going to do grit. It's your gears to think about how your carefully constructed US plan starts to come apart in the seams, or risks coming apart in the seams, when we introduce some UK tax rules. And we're going to look at where possible solutions, but also where some potential pitfalls lie here. The place I want to start was the place we left off in the previous episode, which was talking about sort of the question of foreign versus domestic, or as the UK would say, sort of resident versus non-resident. Our terminology isn't quite so grand. For UK purposes, residency means where the trustees are. And if you've got wholly UK trustees, it's a UK resident trust. If you've got wholly non-resident trustees, it's a foreign trust. In between, it depends. The US has a slightly more sophisticated test, is it not, which I always refer to as the court and control test, but never really understand what that means. So how do you, Jake, as a US practitioner, determine whether your trust in question is a foreign or a domestic trust?
Well, I should just let you do this section because the court and control test is exactly where I was going to start.
Yeah, but what is control? I mean, court, I'm assuming, is something to do with court oversight, but I mean, like, what does that mean?
Yeah, no, exactly. So I want to touch on that and also some nuance that is involved also with the various U.S. states. But at sort of a high level, we consider a trust to be a foreign trust if it does not satisfy both the court test and the control test, right? And the court test is exactly what you just said, right? Does a U.S. court have primary supervision over the trust?
Control test is fairly clear. Presumably,
yeah,
it's
exactly.
The trust is governed by the laws of a US state. If it's governed by the UK law, it's going to fail the court test.
That's right. The control test is, as you said, a little bit more nuanced. I mean, the sort of the question to consider there is, do US persons have the authority to control substantially all of the decisions of the trust, right? So I think it's pretty clear that if you've got a US person who's the trustee, that causes you to pass the control test. If you've got multiple trustees and some are U.S. persons and others are not, it can get a little more complicated. If you have, trust protectors with certain powers that are broad or are not so broad, it can kind of be a sliding scale. But sort of at a high level, U.S. person as the trustee typically causes you to pass the control test.
Just to be clear here, when you say U.S. person, can you unpack because this is where I was going to take you to. What do you mean when you say U.S. person?
So we mean U.S. citizens, and we mean U.S. residents who live here for certain numbers of days on the income tax side.
The citizenship was the point that I was really, I was getting you towards, because of course it's perfectly, I mean, I forget the statistics of how many 100,000 Americans live in the UK, but if you have a trust that has an American trustee and it's subject to US law, you have a US trust, a US domestic trust. The US, we're back to everyone's favorite taxation by citizenship, right? The fact that you are a US citizen makes you a US person for these rules. And so it's just that I just wanted to take that opportunity to remind everyone, the Americans, along with Eritrea, are unique in the world in taxing by citizenship. So just be careful when you've got US citizen trustees.
Yes, that's right. Some people are very excited when they become US citizens, only to be very much let down when they hear about what that means from a tax perspective.
The sting of the tail.
Yes, that's probably the topic for another podcast. But
yes,
it's a little teaser to get your crowd excited.
You were going to move me away from the exciting talk of federal taxation to the even more exciting talk of state taxation before I interrupted you.
Yeah, so one point that always is sort of fun for the sickos like you and me that live in this space is, where is a trust resident for state tax purposes?
Mm-hmm.
And the sort of fun and sort of squishy answer to that question is, Depends which state is trying to tax it. In states like New York, one of the questions is, where did the taxpayer reside when the trust was funded?
Mm-hmm.
In other states, we only care about, are there any trustees or beneficiaries who reside in a certain state? That means multiple states could claim the trust is resident in their state and attempt to tax it. There are some credits that would offset one another, but you can have a foreign or a domestic trust for federal tax purposes. But even with that being the case, if it's a foreign trust, in theory, certain states could still claim, no, this trust is resident in New York or what have you.
I love
And
that
so,
aspect of US tax law where you can be federally non-resident but state resident. It just makes no sense at all. But it's, that's the US rules.
yeah, it's not for the faint of heart, Aidan. I wouldn't recommend it for anybody who's had any heart problems or anything like that. But the point is, there's sort of a mishmash of rules. It's sort of state by state, and if your trust has any connection to any state, it has to be part of the analysis because it can be otherwise quite a surprise.
Yeah,
an unpleasant one.
And so, getting to the sort of the meat of the question or the meat of the topic, which is what usually comes up with UK trust planning, is what happens when you've got taxpayers in both jurisdictions as regards a particular trust. Now, we have discussed on this podcast before the concept of double taxation and relief under a tax treaty, but we can never say it too many times. The issue with trust planning is generally going to arise where you've got taxpayer in the US who is not the same taxpayer as a taxpayer in the UK, or maybe where they are the same taxpayer, but they're paying tax at different points in time, separated by different tax years, for example. So you've already said, Jake, that if you've got a US domestic trust and it's a non-grantor trust, the trustees are paying the tax. If it's a grantor trust, the grantor's paying the tax. For both of those purposes, if a beneficiary is then residing in the UK and receives a payment or a distribution from that trust, it's the beneficiary who is broadly going to pay that tax. And so you've got a mismatch in taxpayers. And I'm sure you're going to tell me that shoe on the other foot, it's exactly the same. If you've got a foreign trust, but it's a UK resident trust, I'm going to expect to tax the trustees. And then when I make my distribution of principal of capital to my US citizen beneficiary, you're going to expect the beneficiary at that point to pay the tax.
Yes, that's true for the most part, right? I think what the IRS sort of largely cares about with regard to who pays income taxes on trust assets is that somebody pays those taxes, right? There's a lot of planning in the United States around, should the trust pay this tax and then distribute out after tax money so the beneficiary doesn't have to, or should the trust spit out everything and let the beneficiary pay the income tax? And that depends on a lot of factors, right? I mean, it depends on income tax rates, it depends on relative assets. It can depend on step-ups and basis. I mean, it can depend on a lot of different things.
Well, but therein, and you have by luck or by design, teed me up for exactly the thing I was going to say next, which is that is one of the discussions that you and I will have with lots of individuals, which is, okay, well, the default rule is, in your scenario, the default rule is that the trustee pays the tax in the US, but have we got a way of shifting the tax burden in the US from the trustee to the beneficiary? So I believe you told me before about paying out all of the ordinary income in a domestic trust each year, or if we make an in-specie distribution of assets to an individual rather than selling assets, realizing cash and distributing the cash. Those are both ways I've been told by US practitioners before about shifting future burden or current or future burden down to a beneficiary. And we may be able to line up the tax charge in the US with the tax charge in the UK. And we've got a much stronger chance of claiming a credit because now we have the same taxpayer paying the same tax in the same fiscal period. But that's the devil that the detail lies in, right? So that's how you sort of try and move from this position of, oh God, we've got two different taxpayers and what are we going to do about it because there is double taxation here. And that does sometimes happen. Ooh, we may have a chance now of if not claiming a credit for all of the tax paid, you're at least in a much better circumstance.
Yep, I think that's right. And, to make things even more complicated, right? Sometimes we can overlay the idea of, do we actually want assets to be included in the U.S. taxable estate, but not included for income tax purposes, right? And that's what we call intentionally defective grantor trust planning in the United States. And, we have that high exemption that we talked about in the last episode, 12.92 million in 2023. So sometimes we have a situation where we want assets to be included in someone's estate because they don't have enough to reach that 12.92. But at the same time, the income is such that we may want it sort of on one side or on the other side. And often that's driven by, do we want to step up in basis, right? Do we want those assets to pass to an heir, the heir get the value for the basis purposes as of the date of death, and then the tax paid on that versus the tax paid on the prior basis, right? So we always try to write trusts in a way where we sort of situate them offhand, initially as either grantor or non-grantor, but we always want to include a provision where we can kind of turn that treatment on or off depending on what the circumstances there may be, right? Another fun nuance.
You've again teed up perfectly the teaser, or the one nugget I was going to give those that are still listening to this discussion and haven't switched off or fallen asleep, which is
one of them.
Oh, exactly, or one of them. My mother's still listening. Mum, you're listening in 4 months' time. I'm sure you're still listening. One of the things that we do frequently is we turn to the double tax treaty and we try and find ways in which to use the credit system of same taxpayer, same tax, same fiscal period to our advantage. There are not very many, I'm going to say one or two, exemptions or reliefs or caveats to that general position where you do get a tax credit where one taxpayer is in one jurisdiction and another taxpayer is in another jurisdiction. And what the exchange of notes to Article 24 of the US-UK Double Tax Treaty says is that you can get a credit in the US and UK if the grantor, if the settlor is paying tax in one jurisdiction and a beneficiary is paying tax in another jurisdiction. So to your example, most frequently, the way that we in the UK see it is if you have one of your defective trusts where the grantor is still paying the income tax liability in the US and a distribution is made to a child in the UK, the child in the UK has a tax liability which is available as a credit to offset the grantor's US exposure. Now, that doesn't improve the exposure for the child in the UK, but you are improving the exposure for the grantor in the US. So you are at least getting a credit somewhere. So the overall tax paid by the family is going down, which may or may not be scant consolation to the child in the UK, but I mean, they're benefiting from wealth set aside by their parent. Maybe they can take that one on the chin.
I think that's right. And I think you've sort of indirectly highlighted a point that I think is always really, really important with cross-border planning. One of my mentors and bosses at Alston and Bird is a gentleman named Mark Williamson, who's sort of a brilliant international estate planning attorney, rather, in my view. And he always says the number one rule of international estate planning is get local counsel. Get local counsel, right? Do not try to figure this stuff out on your own, right? I know enough about UK tax law to be dangerous, if that, right? And paying your firm a few bucks to figure out the UK side of it or work with me pays itself off 1,000 times over.
You lead me into the section which on my notes here says, what should US practitioners do if someone is UK resident? Of which number one is take joined up advice. So I completely agree with you. If everyone took advice, the world would be in a much better place. Now, clearly, double advice means higher costs, but I promise you the consequences of the tax almost always outweighs the professional charges. And if the professional charges outweigh the tax, then we'll probably let you know it's just not worth taking the advice in the first place.
Sometimes it's a matter of calling you and asking you one quick question.
Yes.
Right. And you'll answer that question gratis because it's going to take you 30 seconds.
Of course.
Answer. Right. Now, sometimes it's more involved and we have to engage you and all that. But, it's foolish to have resources like Collier Bristow. And then when I have a UK client, not call them. Right. I mean, why wouldn't anybody hire Collier Bristow? Right. I mean, I can't imagine that.
Oh, what a generous statement. I'm always reminded of Donald Rumsfeld's famous quote about known knowns and unknown knowns and known unknowns and unknown unknowns. Again, I know I have a known unknown about US tax law. I know there's a problem, but I certainly don't know the answer. But I know enough to know I need to pick up the phone to you to say, Jake, I've got a credit shelter trust with these kind of characteristics. What are the kind of things I should be thinking about? And at least at the beginning, getting that issue resolved, or at least the issue scoped, framed, is a big help. And doing it early is the other thing, right? So rather than my client's just had a distribution from a trust, what should we have done? My client is about to get a distribution. Is there anything we can do? Or my client is thinking of moving to the UK. Is there anything we should do before they come to the UK? Not they've just touched down wheels at Heathrow. What should we have done beforehand? And undoubtedly, a lot of your time is spent talking to clients about saying, if only you'd given me a little bit more time, if you'd given me an extra 6 or 12 months, I could have done a lot more. But such as it is, these are now our options.
Yes, exactly. You always want to, be ready, aim, and then fire, not be ready, fire, and then aim, right? And I agree with you 100%.
The other thing that I think is probably unique to our circumstances, but certainly one I see quite a lot when dealing with UK beneficiaries of US trusts, is there is a big difference, if not in the abstract tax rules, but in how you apply them, between, on the one hand, say, I'm one UK resident beneficiary who has a 5% share of a large multi-dynastic trust set up by my great-grandfather in the 1930s, and I'm about to get my small share on the death of someone before me, versus, on the other hand, I set up, or my father set up, a trust 5 years ago, and I'm going to get a distribution of all of the trust assets now. Those are both governed by the same US-UK cross-border planning concerns, but in one, the UK is a very small fish in a much larger pond, and in the other one, all the money is coming out to someone in the UK, and you need to think about the rules in a much more harmonious way, and you probably have more influence over what happens. So that's the other thing, is recognizing which jurisdiction probably is the power broker here, which jurisdiction is controlling all of this, and does the other jurisdiction have enough influence to say, could we do things slightly differently? If we in the UK have to play second fiddle to you, Jake, it's fine. We understand. We'll slot in around you. If we've got some more influence and an ability to change direction, then so much the better. And then we, usually have more scope to be tax efficient.
Absolutely. Yep. I agree with everything you just said. Again, as we said before, you never want the tax tail to wag the dog, but sometimes there are simple things that can be done that can pay for themselves, 1,000 times over. And we always want to make sure we're aware of those things by consulting with you, and that we pick the logical strategy.
I think if anyone does want to consult with me, or does want to consult with Jake, and like I said, is still alive and awake at the end of this discussion, I'm sure he or I will be most happy to discuss these issues with you. Please do just get in contact with us. I'm sure if you Google either of us, I certainly hope if you Google either of us, you'll find us quite easily. Jake, thank you so much for joining me today. It's been an absolute pleasure to carve through this issue with you. Again, Jake, Kaplan, Alston and Bird in Atlanta. To you, the listener, thank you very much. Please leave us a review wherever you found this podcast. It does help us expand our audience. And so we thank you for joining us. Please listen again next time.